Karen Reed's civil attorney, Damon Sellingson, is clapping back in several of the cases that are pending Proctor's 10,000 plus messages that were left on the iCloud slash Proctor lost his phone. Damon Sellingson states that in a filing in both of the Myles King case, the Bianca case, De Los Santos case, and Johnson case, Michael Proctor lacks standing to object to the Commonwealth's agreement to produce documents currently in its possession in response to a civil subpoena, despite his desire to hide his apparently appalling conversations with fellow law enforcement officers and others, which he clearly assumed would remain permanently shrouded in secrecy of his group chats. That is one of the pages. Let me go to the next one. They cite some case law holding that even a party to a case, which Proctor is not here, does not have standing to object to a subpoena to a third party unless it raises a colorable privilege or privacy issue. As referenced in the Commonwealth's motion, both the family of John O'Keefe III and Karen Reed served subpoenas on the Norfolk District Attorney's Office in the ongoing civil case between them. The Norfolk District Attorney's Office and the parties to the civil case negotiated and executed a confidentiality agreement whereby the Norfolk District Attorney's Office would produce certain previously identified documents concerning Proctor's potential bias. Proctor filed an opposition to the Commonwealth's motion for permission to comply with the agreement, to which Proctor is not a party. The Commonwealth's motion should be allowed because the O'Keefes and the Reed are not fishing for information, because Proctor's counsel has already reviewed the documents at issue and removed any that were privileged, because Proctor cannot use his own spoliation of evidence and violation of others' individuals' privacy rights. That is page 2. Page 3 states that as the Commonwealth motion confirms, neither Reed nor the O'Keefes have ever received these messages. They are completely separate from the text messages in Reed's criminal defense team and the Commonwealth received during the criminal trials, which Reed has now produced to the O'Keefes. Specifically, Reed understands from the Commonwealth that the messages in questions were recovered from a messaging application, not the phone's text messaging records. The Commonwealth, which prosecuted Reed twice for murder and is clearly not biased in her favor, determined that the particular documents it intends to produce go to Proctor's bias and have not been previously disclosed. These are not the makings of a fishing expedition. This is simply an attempt by the Commonwealth to produce specific curated documents on a particular topic of two parties on opposite sides of a pending civil case. In order to comply with its obligations in response to duly served subpoenas, in fact, through compliance through this court's orders, the Commonwealth has already made a determination that these specifically select documents are relevant to criminal investigations. Proctor ran, which includes Reed's prosecution. They are therefore obviously relevant to the civil litigation that relates to the very investigation and prosecution. The documents in question are also not privileged. Pursuant to the court's previous orders, Proctor's prior counsel had an opportunity to review and remove the documents. Anything he asserted were subject to the attorney-client or marital privilege before any production took place. Finally, Proctor makes two cynical and meritless arguments. First, he writes in his opposition that he lost his phone and no longer has access to it. Therefore, as Proctor well knows, that the O'Keefes and Reed can only obtain these potentially relevant documents from the Commonwealth, and Proctor should not be permitted to blatantly rely on his own spoliation of evidence to keep his bias and offense speech shrouded in secrecy. Proctor attempts to grotesquely leverage the fact that his own messages on his own phone contain explicit images of women that did not consent and are unaware of their photographs being shared. After apparently violating their constitutional and legal rights by privately obtaining, keeping, and using these images for his own and his friends' personal predilections, Proctor attempts to notably set forth his opposition, his abiding concern about these women's privacy rights. He argues that the court should prohibit the Commonwealth from producing his otherwise discoverable discoverable communications in which he long ago abused women's images to protect these same women. The irony should not be lost on the court. Proctor should not be permitted to rely on his own inappropriate and potentially illegal act of sharing other people's intimate photographs to prevent discovery of that very act, among others. Nor should he be allowed to hide his bad acts on his apparently newfound respect for third parties' expectation of privacy. This was filed again by Damon Sellingson in the Karen Reed case, but it goes to those 3 cases or 4 cases that I talked to you about before. Remember, Myles King is coming up. Is this where we are going to see some of Proctor's 10,000 plus messages that were found on the iCloud coming out? So make sure to like and follow and stay tuned if you want to hear and see what is going to come out. Myles King, they are pushing for a trial date. Are they trying to push it before a new Norfolk district attorney is going to take office later this year? Stay tuned.